Is it official? Now my mic's on? All right. Welcome, everyone. I am Amy Wildermuth. I am the dean here at Pitt Law, and we are very happy to host again the annual Constitution Day event for the University of Pittsburgh. We are delighted to be hosting so many of you in person as well as online. Thank you for being here. I hope you will join me now in thanking the team that put this together, and I want to especially thank our own Debbie Brake, who has been so thoughtful and careful in all the programming for today. So please join me in thanking her. Thank you, Debbie. Constitution Day commemorates the signing of our Constitution on this day 234 years ago. It is a time for us to reflect on the words and spirit of that document and to measure whether it will continue to endure even as so much shifts and changes around us. The Constitution and the debates around it reflect much of how we as a nation have struggled over time in our collective quest for justice and a more fair society. This event and others like it allow us to consider those challenges from new perspectives and can inspire us and lead us in new directions. At Pitt Law, we have always understood that this is a day to wrestle with the most timely and relevant issues of the day. From marriage equality to immigration, from hate crimes to presidential power, this lecture has always been an opportunity for us to shine a bright light on the critical issues of the moment. Today, we are particularly fortunate to have Professor Robert Tsai with us today to talk about our democracy, elections, and voter rights. I can think of no more important issue for us to take up in our pursuit of equal justice under law. I am very glad you have all joined us, and I extend my very warmest welcome again to all of you. To tell us more about our terrific speaker, I will now turn things over to Professor Brake. Thank you.
Good afternoon, everyone. I am truly delighted to have the honor today of introducing Professor Robert Tsai, our 2021 Constitution Day speaker, who comes to us from Boston University School of Law. And like Dean Wildermuth, I am particularly delighted that we are able to hold this event in person as a hybrid with a Zoom option. But seeing your faces in the room makes me very happy. And I want to thank Dean Wildermuth in particular and the fantastic, tireless working staff, including Kim Getz, who have made this possible and whose mostly unseen work every day has enabled us to navigate the challenges of this pandemic as seamlessly as possible. So thank you. As many have said in generations before ours, we live in interesting times. Never in my lifetime has this felt more true than the present. At this constitutional moment, we truly could not have found a better choice for our 2021 Constitution Day lecturer than Professor Tsai to help us understand the present state of our democracy and to put it in constitutional and historic context. Professor Tsai is a prolific author and scholar of constitutional law, constitutional history, and popular constitutionalism, as well as the First Amendment and the Constitution's promise of equality. He's the author of 3 books: Practical Equality, Forging Justice in a Divided Nation, America's Forgotten Constitutions, Defiant Visions of Power and Community, and Eloquence and Reason, Creating a Constitutional Culture, all of which have received rave reviews. And he is close to finishing a 4th, Ask the Impossible, Race, Poverty, and One Man's Quest for Equal Justice, an exploration of the life and work of Stephen Bright, who led the Southern Center for Human Rights for over 40 years. This latest work connects Bright's legacy to pressing lessons for today, challenging prison conditions, capital punishment, and mass incarceration, and we are eager to read it. Professor Tsai is also the author of many law review articles, too numerous to detail, but they too have garnered the very highest praise, including two of his earlier works being recognized by the Stanford-Yale Junior Faculty Forum. He's a graduate of Yale Law School and of UCLA. He clerked for Judge Denny Chin of the Southern District of New York and Judge Hugh Bounds of the First Circuit. Lesser known is that Professor Tsai, and this is unusual for the Legal Academy, is an astute user of social media. You can follow him on Twitter, and if you do, you will see his post from yesterday enjoying the sights of our fair city and some snacks from the Pittsburgh Popcorn Company. Professor Tsai, I want to thank you for joining us today. We are truly honored to host you for this very important lecture. And for those of you on Zoom, you will be able to type any questions into the Q&A, and I will be monitoring them, so I encourage you to use that function. And for those of you in the room, if you have questions, we should have some time after the lecture for discussion. Thank you, Professor Tsai.
Thank you, Debbie, for such a wonderful introduction. Thank you to Dean Wildermuth for having me, to the faculty of the University of Pittsburgh Law School for the invitation to address all of you. One of the things that Professor Brake didn't mention was that is where we first met, which I won't tell you exactly how many years it's been, but we met at one of these conferences that she mentioned, and of course I was enthralled by her own scholarship in the area of discrimination law, and it's a pleasure just to be back here to see her again. Thanks for all of you for coming as well. What I'd like to do today is to invite you to return with me at the beginning of my talk to one of the darkest moments in our constitutional history. January 6, 2021. I'll never forget where I was on that day. I was sitting there in front of my computer in my home because of the pandemic, glued to the events unfolding on my laptop, watching, horrified as the unthinkable happened. Supporters of the sitting president engaged in a street fight with Capitol Police. The crowd eventually storming the building as our constitutional process was trying to reach a completion. Interrupted because those who stormed the Capitol tried in a desperate bid to halt the counting of electoral votes in the hope of somehow helping Donald Trump to hold on to power. Now, some of you may have also been watching TV or following along live that day. Besides the horror of it all, the events of January 6th were burned in my memory for another reason. I was actually a captive audience member because I had agreed to offer live commentary on the joint session of Congress as Congress received each state's electoral votes. And so there I was, mic'd up on live TV, and I had just answered a question when Mike Pence, of course, and if you were watching the events, suddenly rushed out of the chamber. And everyone was like, what is going on? And for the next 2 hours, they kept telling me in my earpiece, just hang on, because we'll just, I'm sure this will just be a momentary intrusion. And we'll get right back to the counting. And so for the next 2 hours, I was mic'd up on standby as the scenes grew ever more chaotic and violent. Now, how do we get to that awful moment, January 6, 2021? Well, after a close-fought election, Joe Biden had prevailed over the incumbent president, Donald Trump, in a number of key states: Arizona, Pennsylvania, Michigan, Georgia, Wisconsin, lifting him to a healthy electoral college victory, 306 to 232. Now, unlike recent situations, such as the 2016 election or that of George Bush in 2002, the winner of the Electoral College also carried the popular vote. Biden's margin of victory in the popular vote turned out to be decisive, right, by over 7 million votes. So according to every indicator that mattered, Biden had done better. So on January 6th, when Congress met to receive those electoral votes from the states, they were performing the final step required by our Constitution and by federal law. It should have, in many ways, been just a formality. Of course, there had been contested elections in the past, such as the 1876 Hayes-Tilden contest. But there, the contested states had been so conflicted that they ended up sending slates, dueling slates of electors to Congress. And there were serious allegations of fraud and wrongdoing. And at that moment in time, there was no clear federal law as to how to settle such disputes. That changed after the 1876 debacle, with federal law clarifying that electoral disputes would be solved or resolved through a joint process that required both chambers to reject a state's electoral votes, to only allow them to reject the electoral votes through a complicated process where both chambers would have to vote separately and agree to exclude them. Although this should have been largely a formality, we saw signs of disquiet. Since November, a president who had lost had stewed in the Oval Office for months, increasingly isolated by longtime aides or from them and from steady hands, surrounded instead by hangers-on and conspiracy theorists who urged him to contest the election by all means necessary from the outside. People like Steve Bannon and Lieutenant General Flynn, who've been cast out by more serious aides, returned with a vengeance. Now, at first, the campaign filed lawsuits like many other candidates who lose close elections. But steadily, those losses piled up in court. Allegations of fraud were never proven. Recounts did not produce major changes in vote totals. And finally, multiple layers of courts, state Supreme Courts, federal district courts, federal appellate courts, and finally, the Supreme Court of the United States twice refused to disturb the outcome. As the lawsuits failed, 62 separate lawsuits filed and lost, lobbying of elected officials to overturn the election results not only began, but intensified. Efforts to lean on election officials, governors, secretaries of state in charge of overseeing elections, even county officials in states like Pennsylvania, that gives county election boards a minor role to play in certifying election results. And no one thought then it was a coincidence, or they should not have thought it was a coincidence, that the president's close supporters from the outside were planning a large-scale event that just happened to take place on January 6th, the very day that Congress would finally be meeting to receive those votes. Then came the storming of the Capitol. As Bob Woodward and Robert Costa report in their book that just dropped about the final days of Donald Trump's presidency, Steve Bannon reportedly told his allies, quote, "We're going to bury Biden on January 6th. Anyone who studies political extremism in this country or the fall of democratic governance in other countries knows what desperate people in power are willing to do to hang on to power. And at the time, it's quite clear that certain aides, as well as military officials, were also worried. Now, there are other moments like this in one's lifetime, thankfully not very many, where democracy and the rule of law suddenly seem much more fragile than it has ever been. In my lifetime, there have been a few. The Supreme Court ending Florida's recount in the 2000 election, which delivered the presidency to George Bush over Al Gore. When the first plane struck the North Tower of the World Trade Center on 9/11. Timothy McVeigh's bombing of the federal courthouse in Oklahoma City. Each of these events reminds us that democracy is a practice that is under threat, not only from without, but also from within. Now, I think there are two ways to think of January 6th. Let's call them the glass half full and the glass half empty. The glass half full view of January 6th is that the system we have survived. Federalism held. Democratic norms were tested but sprang back. Despite the system's multiple points of vulnerability at crucial moments, and despite party affiliation, heroic individuals did their jobs and resisted the pull to please their friends and benefactors and to hurt their political enemies. This account, by the way, the glass half full account, gives due credit, and I think this is deserved, to Vice President Mike Pence, who found a way to ignore his president's multiple entreaties and all of his own personal political instincts, which told him to please his benefactor and the most popular figure in his own party whenever possible, that his political future depended on it. But there's also a glass half empty interpretation of what happened on January 6th and what that day signifies. On this view, those events are not just about a norms-breaking president who leaves office as he entered it in absurd, norms-breaking fashion. Rather, this interpretation of those events requires seeing that a disaster was only nearly averted. If one or two states had been closer, the temptation for the Supreme Court to step in, which it had done before in a close presidential election, or the temptation to engage in a partisan power play by a vice president, might have been much harder to resist. On this view, again, the glass half empty interpretation, we have been living in an ancient constitutional order that is all too easy to exploit. These moments, in other words, shouldn't be ignored because they are signs that something deeper is not quite right. We ignore these signs at our peril. Indeed, what I'd like to do today is to try to persuade you that democracy in America is likely to remain just as fragile as you thought it was on January 6th, as those events revealed it to be, unless we engage in major reform. The truth is, and this is where we should start, that we've not really been a democracy for that long in this country, about 50 years or so. We certainly weren't a democracy at our founding. A deep suspicion of their fellow men, especially the poor, and especially of the French, who were rather wild in the streets during the Revolution, led the framers to favor what I consider to be the aristocratic elements of our legal and political tradition, particularly the civic republican tradition, over what we might call the plebeian or the more populist elements of our tradition. Now, this is reflected most visibly in the absence of a guarantee of equality in our original Constitution, or even the right to vote. It's also reflected in the framers' consistent design choices that favored the diffusion of authority and a preference for indirect forms of governance, that fear of, in some ways, the people, although they were acting in the name of the people as well. Every year, my students are shocked that America's first charter, the Articles of Confederation, carved out groups of people from its protections. Paupers, vagabonds, and fugitives. So the poor were expressly excluded from the rights, the privileges, and immunities that other citizens enjoyed. The first glaring problem that we need to focus then on is that the right to vote in this country is not constitutionally secure. Even during a truly revolutionary moment, that is, Reconstruction, the right to vote could not be guaranteed in the strongest terms. Yes, it's mentioned in the 15th Amendment, but to see why I am making this claim requires probing history to see that the most radical Republicans, that only the most radical Republicans supported giving free Black people the rights of citizenship. But most white moderates at the time, including leading abolitionists, and even Abraham Lincoln himself, proposed ending slavery, but then embarking upon a program of voluntary removal of emancipated slaves to another country, such as Liberia. So the 15th Amendment is best understood as a compromise of the politics of that day, limited by the political imagination of that time and the cultural limitations of the people who engaged it, as well as the racism of the age. The 15th Amendment merely forbids the use of race to interfere with the franchise, but otherwise leaves it to states and even local governments to enact a host of laws to regulate, and if a jurisdiction so desires, to make it extremely difficult to vote. The Reconstruction Amendments, and here I'm also including the 14th Amendment, also left open the use of felon disfranchisement. Let me try that again. Felon disfranchisement. See, I stumble over that because actually people use that phrase in two ways. A loophole that has been exploited by states to take the vote from millions of Americans, in many cases, to never give it back. From Alabama to Virginia to Florida, felon disfranchisement has been used to target Black Americans, but doing so in formally race-neutral ways. Today, more than 2 million African Americans are still prevented from voting for this reason. So due to criminal enforcement policies and aggressive disfranchisement practices in some states, 1 out of every 13 Black citizens among us will lose the right to vote sometime during his or her lifetime and may not regain it. I was shocked the first time I read the debates of Virginia's 1902 Constitutional Convention. If you're interested in this subject, that's where I would send you. When leading Democrat Carter Glass proposed expanding the list of crimes for which a citizen would lose the right to vote. This was well after Reconstruction. And so Glass led an effort to engage in what he called, quote, discrimination within the letter of the law, or so he said. What he promised to do during this convention was to eliminate 4/5 of Black voters from the voting rolls. Now, this sounded far-fetched to some of his colleagues at the time, and so they pressed him like, well, you know, won't this end up excluding the occasional white voter, right? Because they might commit one of these crimes. But Glass was confident that his strategy would succeed. And the reason why he ended up being right, because it wasn't a blind guess. It was an educated one, based on Alabama's experience, using felon disfranchisement to stop what they then called, quote, the menace of Negro domination. So that's exactly what happened. Virginia enacted a sprawling disenfranchisement provision in its state constitution, and indeed 4/5 of voters who were Black were taken off the rolls. Perhaps, now here's a bright spot, one of the most heartening acts of democracy I've seen in recent years. In fact, I'm trying to think of what the best one was before this moment, but was the effort by everyday people in Florida to rewrite their state constitution and undo some of the damage to our democracy that has come from felon disfranchisement. Florida is by far the worst state in the country in abusing this power. In Florida, until recently, well, actually, this is still the case. Any felony, a single felony, will lose you the right to vote. And until recently, you had to petition for your vote to get it back, leaving it entirely subject to bureaucratic and partisan whim. And you would see the differences that, governor of one party would grant a whole bunch of these petitions, and then governor of another party would grant very few petitions. So what happened recently was that in using the initiative process, citizens in Florida, and indeed 65% of people who voted, approved this amendment, which restored the vote to 1.4 million voters. That's a shocking amount of reform in a single vote. And so I take heart in that, and I think you should as well. Now, the story is not over, because what happened next in Florida was that the legislature and governor were both opposed to that citizen initiative, and they worried about the partisan benefits they felt that the other party would gain. And so they subsequently enacted a law to try to frustrate the effects of this popular amendment. They passed a law requiring that all fines and fees would have to be paid before a person who committed a crime could get his or her vote back. This law was challenged in court, by the way, and it went up and down the federal system, and the 11th Circuit eventually upheld it. What that means practically is that some 800,000 Floridians then cannot take advantage of the reform that had been enacted by their own fellow citizens. And the only reason why they can't is because they're too poor at the moment to be able to pay back some court fees and fines. That's the only reason. Of course, this is an outrage, isn't it? But it should also be seen as confirmation of something else that I want us to think about, and that is the weakness of the constitutional guarantee of the vote, when it's not even mentioned as explicitly as it could be in our Constitution. Before we leave the topic of felon disfranchisement, let me just say this, that I think that the case for ending it as a practice is rather straightforward. Yes, it is a power that has been a traditional one that we could trace all the way back to this notion of civil death in Athens and later in Rome. But I would argue that that practice today is incompatible with the idea of a modern democracy that prizes individual and even robust participation if we can get it, and which looks askance at the idea of legal stratification that a practice like this perpetuates. And a system that today, I hope, is more troubled by things like historical patterns of racism, which this practice clearly has been involved with. What's more, the 14th Amendment, which references the practice, was written at a time when people worried intensely about ex-Confederate soldiers and statesmen engaging in criminal and not just rebellious behavior that could undercut the Civil War's legacy. And many others didn't even want emancipated slaves to vote. That was the compromise. So, widespread loss of voting rights today in the age of mass incarceration shows us what we have lost and what we can still regain. If we cared about rehabilitation, we wouldn't tolerate a system that left people without basic rights of citizenship. If voting were truly a fundamental right in this country, which we often like to say, then the haphazard way in which different states treat the right to vote would not be tolerated. And indeed, what I think needs to happen is that we need to strengthen it in the Constitution itself. The absence of strong constitutional text guaranteeing the right to vote has done something else. And you may have picked this up today in contemporary political debate. It plays into the hands of those who argue that there is no such right, that voting is merely a privilege, something that any state can burden or take away. Indeed, in the wake of baseless claims of election fraud, a number of states have restricted access to the vote by imposing new conditions or curtailing the availability of voting locations or voting methods. The power to purge names from voting lists have been expanded in battleground states, raising the risk that voters will be erroneously removed and that they won't learn of that purging until it's too late. In Georgia, the legislature just cut in half the time in which a Georgia voter may request an absentee ballot, has imposed an ID requirement to even ask for absentee ballots, has banned mobile voting centers, and has even made it illegal, it's got a lot of attention, to give food or water to people standing in line for hours. There's more. Georgia also just removed the Secretary of State as a voting member of the state election board and empower the state legislature to remove county election officials. And you might ask, well, what's wrong with that? Because what they argue is greater accountability, but the flip side of that is a greater likelihood of political intrusion in actual elections for partisan purposes. Some states have passed laws that require IDs to be shown or proof of citizenship if voters' names are flagged. And we know for a fact that such a rule or such a practice has impeded naturalized citizens whose names have gotten flagged and stopped them from voting. Creative methods, particularly in a pandemic, that were tried to make voting easier for workers, such as what Houston did with drive-through voting and expanded hours, have been explicitly banned. So we won't see that again, at least in Texas. That the Constitution's protection of the vote is so spare invites such heavy regulation, even as other states are actually making it easier to vote, especially if you are poor, especially if you're a person of color, or you just have obligations that are hard to slip away from, to stand in line for hours. These moves also put us behind other countries, and even some states within our own country, that have engaged in wholesale effort to rethink fundamental questions such as how to allocate powers and rights. For all the talk about our country's tradition of popular sovereignty, the reality is that people have gotten more and more exercised about a smaller menu of things, all the while refusing to draw a connection between their own discontent and the flaws of our constitutional design. The right to vote, and indeed the very idea of America as a modern democracy, is held together with so much string and scotch tape. We hold on to the fiction of an unchangeable constitution, but it's actually transformative laws such as the Voting Rights Act of 1965 and a series of decisions by judges that really represents much of the legal infrastructure undergirding our notion of pluralistic democracy today. But as we know, decisions can be changed as court personnel change. And as recent decisions by the Roberts Court show us, in which they have undermined the Voting Rights Act of 1965, judges' decisions sway with the politics of the day. There are other major flaws in our constitutional system that we should think about a little more. Lifetime appointment for federal judges has made it easier to entrench partisan policies against the wishes of a majority of voters. A Congress can't enact popular laws so that elected officials find it more satisfying, an easier thing to do to become internet celebrities, rather than engage in the practical science of politics to solve problems. Now, the legal fictions that have brought us to this point can't hold forever. what constitutional law does is it shapes the way we try to solve our problems. It creates parameters for debate and language we can use to persuade others. To some extent, our political culture has gotten sick and gets sicker every day. What we need to do is not just to find new ways to do politics within the existing legal order that we have inherited and focusing on policy change to do it. What we need to do is much more than just urge people to trust existing institutions as they are. You might have noticed Justice Breyer and other justices in the news in recent days. Justice Breyer, a liberal technocrat who vocally opposes judicial reform, does so for fear it might undermine faith in the courts. But he's flat out wrong, because he can't see that judicial reform might actually restore and possibly even enhance everyday Americans' faith in the courts. Justice Clarence Thomas and Justice Amy Coney Barrett have echoed similar themes lately in the news, but I think they are also wrong for the same reason. Though we must also see what they refuse to acknowledge, and that is that they, at least, unlike Justice Breyer, at the moment enjoy outsized influence to block policy changes and constitutional reforms that people might desire, and to undercut the legal achievements of past generations. So what do we need to do? We need to think much bigger, and we need to channel some of the discontent that we are seeing and feeling into efforts to redesign our Constitution. For the best antidote to widespread political disaffection and openness to extremism that we are seeing every day is a government that actually works for regular people. Recently, I took part in a U.S. State Department program. This was really eye-opening, so I mentioned it to you. Co-sponsored with a civil society organization in Chile to discuss that country's ongoing constitutional process. And if you haven't been paying attention, this is really worth kind of checking in on, because it's pretty extraordinary. The Chileans are going through this remarkable nationwide process to rewrite their constitution after a national plebiscite in which 78% of Chileans who turned out demanded a new constitution. Now, that process has been confounding at times, and of course they worry about turnout because this is a country that has experienced widespread disaffection for a very long time. Chile is a country that is now awakening from years of authoritarian governance under Pinochet and those close to him. But what we see there in this process is heartening. Record numbers of women have been elected as delegates to their convention. Indeed, it's virtually half, 78 men, 77 women. There are seats for representatives of indigenous peoples. Many of the delegates who are going to be writing this new constitution come from modest rather than elite backgrounds. They're not just a bunch of lawyers and academics. Women's rights have been put front and center in a way that it has never been in Chile. So this is one of the most exciting constitutional experiments that's happening right now in the world. The Chileans, they may, who knows, end up doing what we Americans have still not done, for example, by writing sex and gender equality, perhaps even reproductive autonomy, into their constitution. So let's try dreaming a little as Americans. Let's put our political imagination back to work. There has been a recent uptick in constitutional reform efforts in this country, though sadly it is, some of it has really been led by academics. The Atlantic, for example, published drafts, if you're interested in this, a progressive and conservative constitution. You can see the differences online. And of course, President Biden has put together a commission to study possible reforms to the US Supreme Court, but we'll see what they recommend. It's a pretty unwieldy group. And what, if anything, the president will actually do about those recommendations. But it's a start, even if it's a limited one. Now, over the last several months, I've been fortunate enough to take part in something I just want to tell you a little bit about, and that was an e-convention experiment that brought together academics from several different disciplines, journalists, as well as concerned citizens. Sandy Levinson, who teaches constitutional law at UT, spearheaded the effort. He was sort of the chair, along with Michael Tomasky, who's now the editor-in-chief of the New Republic. And this was kind of a fascinating and at times frustrating process, and it was all done over Zoom, which was a little nutty, but no one loved every aspect of the Constitution we came up with, and indeed we came up with one. Some behaved like George Mason and Edmund Randolph and refused to sign the finished product at the end. A few of us wrote essays denouncing part or all of the Constitution that we came up with. Even so, what we did on a tiny scale is exactly what we need to be doing on a larger scale, on a more realistic scale. Our proposed new Constitution for the United States and accompanying essays were published over the summer in something called Democracy Journal, and I invite all of you to read it over. Love it, hate it. I'm hoping that it will continue to generate conversation. For now, let me hit a few highlights. The first thing we did was to make it easier to amend the Constitution. Our existing Constitution is way too hard to amend. That's what actually makes it likely to be a suicide pact more than anything. It requires 2/3 of approval of both houses of Congress or state conventions to even propose a constitutional change, and 3/4 of states or state conventions to ratify it. The 19th Amendment, right, is one of those things that failed. Besides the state of our political imagination, this is the formal rule that presents one of the greatest obstacles to the future of democracy. Now, we have been creative enough at times in our past to overcome procedurally near impossible rules of amendment. At the founding, during Reconstruction, and certainly during the New Deal period. But I would submit to you that waiting until a civil war actually happens, or you are on the brink of economic destruction, is not what I would call a good plan for the future. Our proposal would allow a constitutional amendment to be proposed by a simple majority of both houses of Congress, as long as they can do it over time. The proposal to amend the Constitution would then have to be picked up and approved again by both houses after the next House election. And if it is, at that point, it would be sent out for approval by voters, and a majority vote by the people would be sufficient to amend our Constitution. There's another process which I won't get into, which would be a proposal to allow for a citizen assembly to propose amendments to our Constitution, and that would be subject to a higher threshold. Frankly, I think this replicates some of the framers' deep skepticism about popular governance. So I'm not as high about the threshold that was put in there, but there's some effort to offer an alternative mechanism. In our proposed Constitution, we would finally openly describe the political order that we live in as a democracy. This would put an end to the pointless, are we a republic or are we a democracy debate that you may have been a part of at times, which in practical terms has often wound up damaging democracy. In our Constitution draft, we update the Bill of Rights to include human dignity, dignified labor, the right to health and safety and community. The right to vote is explicitly guaranteed. Failure to pay a tax, a fee, or a fine could not be the basis for denying someone the right to vote. We explicitly added sex and sexual orientation and gender as protected by the principle of equality in our proposed Constitution. Now, in states that have already added sex equality to their Constitution, so states like New Mexico, New Jersey, and Vermont, the changes in the language has made a difference. In those states, the Supreme Courts have actually then later ruled that impeding a woman's right to choose is a form of sex discrimination, something that our own Supreme Court has never formally said. We explicitly protect art and scholarship and teaching autonomy in marriage and reproductive freedom. Some of you may have been concerned or are still concerned about mass incarceration. For most of the 20th century, the prison population in America held steady at around 200,000 people in prisons. But starting in the mid-1970s, the prison population began to climb, where it has largely remained. 1.5 million people behind bars or under conditions of release. Today, America accounts for 22% of the world's prisoners, even though we make up only a fraction, 4% of the world's entire population. Now, we chose not to do anything at a national level about this problem because crime is largely a matter left to the states, and we thought it unrealistic for the federal government to try to take over that function. But we did try to improve a few of the procedural protections that have made it easier to incarcerate and to execute people in fighting the war on crime. For example, the idea that the Sixth Amendment right to counsel must meaningfully help poor people is based largely on judicial rulings of recent vintage, 1963 decision, Gideon versus Wainwright, and it remains vulnerable to changes in judicial personnel and tough on crime politics. Under our Constitution, people charged with crimes would have the right to counsel at every stage of the process, including for post-conviction review. You might say, well, why is that so important? Well, because it has been shown that particularly in the poorest counties, places where there are no public defender systems, that the most egregious violations of people's criminal procedure rights happen in those jurisdictions. And often the first time they can be looked at realistically is on post-conviction review. In one of the provisions I added successfully, judges would be constitutionally required to periodically revisit an incarcerated person's sentence to see whether it is still necessary to achieve a legitimate penological objective and that it is not disproportionate. Now, my idea here is to force judges to come back to check again if someone's sentence looks the same once the passions of that particular crime and the politics of the moment have passed. The way we punish now is that judges only have to see someone that one time, and then they can lock you up and throw away the key. Instead, under our proposal, judges would have an obligation to identify punishments that are out of step with democratic sentiment. Our draft Constitution contains some positive rights, such as the right to a decent standard of living. This is attractive to some people. It empowers Congress to impose taxes on income, wealth, and estates. Everyone's entitled to health care. The concern is that a constitutional order in which too many people lack essential social goods and where the government is powerless to deal with enormous wealth gaps between rich and poor is a democracy that can't long survive. Rather, it is an oligarchy in everything but name. Some of the most important features of the Constitution involve reallocations of power and defanging the Senate in terms of being a blockade to legislation and reducing malapportionment. These are sort of creative. I'm not quite sure how this would work, but I'll tell you anyway, so you can sort of think about it. Instead of 2 senators for each state, we propose that states with a larger population would get an extra senator for each increment, and I can't remember what the increment is. So obviously, more populous states would get more senators, and then it would be capped at a maximum of 6. So obviously, California would have 6. But what Californians, people in New York or Texas would want could not just simply be easily blockaded by a single senator in North Dakota. If the Senate would not be allowed to permanently block legislation, but can only force a temporary reconsideration of legislation. So primary lawmaking power would be given to the House. If the Senate doesn't act on a bill passed by the House, it would go back to the House. And if it's passed a second time by the House, then it would go straight to the president for his or her signature. The power to confirm judges would be taken from the Senate and given to the House. This is relevant to where we started. We abolished the Electoral College. we abolished electoral college, or we would abolish the electoral college. That feature has not protected us from demagogues as it was intended. It has given some states more political power to elect a president than others. It has also been a feature that has allowed candidates who lose the popular vote to acquire the powers of the presidency. Donald Trump was not the first person to fall into that category. But with his presidency, we did see something that we hadn't seen before, which is a president who not for a single day in his presidency ever reached above 50% approval. Why is that important? Because the prospect of a candidate becoming president and advancing minoritarian causes, governing, in other words, for a smaller part of the electorate, and entrenching those causes by appointing judges for life, has been revealed to be a design problem rather than a one-off. I believe we will continue to see this problem crop up unless we move to a popularly elected president. Let me jump ahead a little bit. So Supreme Court, we favor term limits, 16-year term limits, although I personally would go even lower to 12 years, perhaps. We restrict the court's power to invalidate congressional laws. It can't be done unless 3/4 of the justices agree to strike down a congressional enactment. And if that were to happen, the federal law would still remain in effect for a period of time, allowing Congress a chance to amend it to minimize disruptions to national policy. If 3/4 of justices deemed a law manifestly unconstitutional, however, then their order could go into effect immediately. Let me wrap up. I appreciate your tolerance. Many of you are law students. I hope that you find the time to think not just about how to interpret the Constitution that exists in your time here, but to find time to think about what a better Constitution could look like. After all, being a citizen isn't just about learning what people in the past did and then replicating it. That just kills the political imagination and renders all of us passive citizens. Instead, the key is to develop a reflective attitude toward the handiwork of our political ancestors, while seeing with open eyes the problematic and even pathological features of a society's fundamental rules. Now, rewriting a constitution won't solve all of our problems, of course. You can't write discretion and judgment out of a constitution. You can't guarantee virtue just by writing it in to a constitution. But writing a constitution, a new one, like the Chileans are doing as we speak, forces people to work together. And it reminds us that it is possible to imagine something different, something new, another way of being. So on this Constitution Day, let's not think about the framers as if they could have anticipated the world that we live in, but instead see them as politicians trying to solve their own generation's problems. Let us not treat the Constitution as an inalterable document, but one that has shown us that it has aged over the years. Instead, let's dream about a new Constitution, one that can finally work for the country that we wish to live in. Thank you very much.
Thank you so much for that inspiring talk. We have some time, a few minutes for questions. I'll ask a question from the Zoom folks and then see if anyone in the room has a question. So the first question from the remote audience is, what are your thoughts on District of Columbia statehood and extending congressional representation to the U.S. territories?
I'm pro doing those moves. This is one of those areas where people have been treated like second-class citizens. In fact, to the point where many Americans don't even realize that people from the territories are citizens. This is kind of, a horrible thing to suddenly realize one day, right? That, it's a relic of American imperialism, and it perpetuates, I think, widespread discontent in a lot of directions. Of course, there's some partisan advantages the Democratic Party would gain, and those can't be ignored. But frankly, I think the objective reasons for doing it, adding DC as a state, finding a way to do that, but in particular doing something about the people living in territories and lack political power is, I think, very important. Yeah, so I'm all in favor.
Thanks for the talk. Can you hear me? Oh, there we go. Okay, thank you. Thanks for the talk, Robert. This was great. My question is, hearing the proposals in the draft of the Constitution that you're working on, I just wonder if it's kind of band-aiding some of the issues that we're trying to get at, because what you're looking at in the criminal context are just what we call collateral consequences of a conviction. And many would argue that that's really when the punishment begins, and that's what felony disfranchisement is, et cetera. So that is what awaits a felon upon release from prison. And so I'm just wondering, how does the Constitution really look at the other problems, education, housing, loans, et cetera, licensing, that a felon faces, which is, I think, are the bigger problems, whether a person can go to justice. Obviously, there are more pressing issues, and I think that your Constitution draft gets that into that.
Yeah, it's interesting. We were divided. I mean, just if you're curious, we were divided in lots of directions. Like there were some people, there's a very strong group of us who thought that the most important thing in a new constitution, if we ever got to that point, was to reduce the number of speed bumps, roadblocks to the expression of majoritarian policy preferences, right? Whether it's the desire for healthcare, whether it is, you know, something else at the federal level, but to make it easier for Congress, particularly the House, right, to get things done when a lot of Americans really get exercised and want to do something at that level. And so a lot of the changes or proposals reflect that. You know, and then there's a group of people who worry a little bit about, let's call them the sort of rights, you know, centered people. And, you know, they still think there's a role for courts to play, particularly, you know, as to issues where you're dealing with unpopular segments of the community, where it's hard to rely on purely majoritarian processes, right, to take care of their concerns. So, you know, there's a lot of sort of toggling between those factions within the convention, which is kind of interesting because in real life, this would also be true. But I think the rights group would be actually more vocal. But, you know, the things you mentioned, some of the things you mentioned, some of the things which made it in the constitutional draft are what we call positive rights, like right to healthcare, right to a decent, like, living wage or something. And, you know, the thing with those kinds of rights, though, of course, is that they're very vague. And, you know, the real work comes after you put something like that in the Constitution, right? Because, you know, how much money is going to go to that, and who's going to be in charge of that, and what is the, you know, what are the institutions that would need to arise in order to make that right a reality? But the reason why I point that out is because I think that there are things that, even if one wanted to put in a constitution, can't be solved at that level of looking at the problem. And so a lot of those, I think those kinds of rights in particular, just simply can't be, and environmental rights. So that's one thing we talked about. I think we have something in there, but, you know, the whole debate was like, come on, really? Like, you know, we can look at constitutions in other countries where they say, you know, everyone has the right to clean air, but then nothing's ever been done. So everything depends on what happens later. Now, there are areas, I think, though, where a certain kind of nudging, right, and empowerment can come from a fundamental document like the Constitution. It's possible, now, and if we had a bunch more, so here's what I think. So you're interested in criminal, like, reform and stuff, and, you know, rehabilitation. I think if we had a bigger group of people who were expert in those areas, we may have wound up with, you know, much more creative things. I firmly believe that. You know, imagine new bureaucratic forms that could be created, something like this. But many of us were maybe not skillful enough in being able to imagine that. And so I think there's a huge open space where people who are interested in constitutional reform can think about, you know, to what extent can something be done at that level, or even incentivize different kinds of relationships, institution building, at the lower levels where much of the enforcement, as you know, is happening, right? State, local level. Anyway, so I think that's just a, a window into how things sort of shook out. But yeah.
I think we have time for one more, and then I'll have a very quick one from the chat.
Hi, thank you so much. I'm very differently situated. I'm a litigator, so I'm actually in court and do a lot of pro bono work. And I think a lot of your talk to me was very inspiring, by the way. But I was thinking a lot about your points about mass incarceration and specifically judicial corruption. I think state courts, there's a lot of issues. And I wondered if you had any thoughts about, practically speaking, in the system we have right now, what can we try to do to poke holes in that, right? Because if we get people out of prison or prevent people from being in prison, perhaps that will help some of these issues. And I was just wondering if you have any thoughts about that or any ideas for somebody who, actively tries to push litigation for those efforts.
When you say corruption, you mean like judges, or you mean prosecutors?
Yeah, so I guess maybe that was an artful term, but there's a lot of issues in the state criminal justice system that tend to disproportionately affect African Americans.
Right.
For example, just pushing pleas. Everyone's pleading, okay?
Right.
Almost everyone's pleading, and that does not mean you committed a crime. Judges push lawyers to push pleas.
Right.
Just judges not really taking things as seriously as they should. We've had issues with mischaracterizations of a very clear record. And as you mentioned, sometimes it takes getting up to an appellate court to really have that review. So just thinking about, what can we be doing in our current system? What kind of litigation can we push to try to force some change there?
Absolutely. No, so this, and Professor Brick mentioned this book project that I have ongoing, and that's allowed me to kind of get into the mindset and into the trenches of someone and his organization in the Deep South, who was doing sort of these criminal justice issues in what we might call the sort of early decades of the war on crime, which became the war on drugs, which became the war on terror. And so he was able to see, his attorneys and paralegals and everybody else, got to see these cases in kind of like what you're describing, in court where things would happen that of a complicated nature that would always wind up to the detriment of the, say, the African-American defendant. And so, the things that he saw firsthand, for example, were consistent prosecutorial efforts in certain counties to create all-white juries, particularly in-depth cases, because, the social science tells us, and so their instinct is strategically correct in the sense that, although offensive to our Constitution, in the sense that, an all-white jury, particularly of men, is more likely to be receptive to pleas for death than if there's even, there'd be women on the jury, or more than one race on the jury. And so, these were some of the things that, that he saw over and over and tried to document. And then the other things were things like argument in court, where certain prosecutors, because I don't want to tar everybody with too broad a brush, but would then, in front of the all-white jury, make certain kinds of arguments they would have never made in front of like a biracial jury. So, for example, using explicit political rhetoric about the war on crime. So one of the cases that I write about is one where there's an all-white jury and a court-appointed lawyer who's not doing much investigation, and then the prosecutor from the all-white jury says, "What you need to do is to think that you are a soldier in the war on crime." That's the way he tells the jurors, and that you're at the front of this war on crime, and in order to be a soldier in the war on crime, you need to give this defendant who's black the death sentence, and they do. So there's that layer of what happens when you've got a breakdown in the enforcement of the principle of equality, right? At jury selection is really what we're talking about. And then, then there are other things. So, on that issue, which was pretty bad for a lot of these cases in this early decades, particularly when the death penalty was reinstated after the case of Gregg versus Georgia. I don't know if anyone noticed this, but Arizona recently just had this interesting thing. They're the first state to now consider getting rid of all peremptory challenges. And here's the other thing that's interesting, which is that it's because two intermediate judges in the court system petitioned the state Supreme Court to say, we see, because the cases have been coming to us for years, that the peremptory challenges are basically a vehicle for racial discrimination, have been for a long time. And so through a rule change, it looks like they're on the verge of experimenting with what will happen when they get rid of all peremptory challenges. And they got to look at how cause challenges are being regulated and so forth, because it might end up just, that they find clever ways to do that. But that's, I think that, you asked what could be done. I think there's certain reforms like that as a lawyer that, state bar can get involved in, and you get wind of it and you get involved with that. But one of the big lessons out of the book that I'm working on for the criminal justice reform stuff is one of the most important things that could happen is a public defense system in many of these places, which often still doesn't exist. And because what's happening in these places where they're still on a court-appointed lawyer system is that the court-appointed lawyer often doesn't have experience in criminal law, feels beholden to the judge for future cases, feels beholden to the prosecutor for future plea deals for his clients, and won't do the investigation, won't ask for money for investigation from the judge. And these cases get either pleaded out quickly, or, and even in the most serious cases, they wind up with sentences that other people wouldn't get if there was actually a public defense system of any sort. So to me, that's one of the things. I think he's right about that, where there are certain places where that reform is still happening. In Georgia is one of the states where they've been doing that. A lot of good can be done through those kinds of efforts.
And I think we have several questions remaining online, but a good place to end would be for one of them, which is, where can we find this proposed constitution written up online?
Someone's interested in taking a look at it. Great. Yeah, it's online. Democracy Journal is the journal. You can find it online, or you can just go on my Twitter account. I think I pulled something up recently, so you can find a quick link that way.
Thank you. Please join me in thanking Professor Robert Tsai for this really, really fascinating lecture. Thank you to everyone joining us on Zoom as well. Got a lot of thank yous on the Zoom chat.
That's great that people tuned in. Oh, yes.
With all of this Wall Street Journal stuff coming out about Facebook and,